What's going on, Conscious Crew? Happy Tuesday. Hope you guys are having a wonderful, wonderful, wonderful work week. We are almost at Mrs. Hump Day. Hope God has been just as good to you as the Lord is being to me and mine. Yes, God. Y'all already know what the hell we're getting into. Before we do so, please go ahead and run those likes all the way up. Thumbing up the video not only helps with YouTube's algorithm, but more importantly, it triggers up YouTube's notification system. So when you are thumbing up the video, you are literally knocking on the digital door of another Conscious crew member and telling them to get their black asses into the sanctuary. Also, if you enjoy everything the Kane does here, you can always donate to the platform at $Consciouztv on Cash App and or PayPal.me/Consciouztv. That's Conscious spelled with the Z on the end, just like it is here on the channel. All donation information and social media handles are in the description box below, as well as scrolling from right to left in red and white at the bottom of the screen. Also, make sure that you have your notification bell set to all. And last but not least, please share the stream out to wherever it is you have digital community, whether that be your YouTube community, wall, your Snapchat, your MySpace, the dark side of Twitter, Tumblr, or your personal OF. I don't really give a damn where you in fact lay the link. Just let them whores know that we're loud, we're live, and we're certainly in color. And with no further ado, let's go ahead and push on through. Oh,
I know a place where you can recharge your soul.
Baby, that's Consciouztv.
And in the midst of brokenness, he gon' see your asshole.
Baby, that's Consciouztv.
You gon' heal, you gon' laugh and catch a little shade.
Ooh, girl.
Y'all know he be slaying, y'all better stop playing. Come hear what he's saying.
Ladies and gentlemen.
what's going on, Conscious crew? Girl, I hope y'all are staying hydrated. I know and hope y'all are staying matte and cool in this damn summer solstice we got going on, baby, because this is one for the goddamn books, baby. I can't wait until she is over. I'm tired of feeling like I am a damn cooked ass turkey. I'm sick of it, baby, okay? The summer done kind of powered me down a little bit, but best believe when Miss Fall and Winter hit, girl, I'm going to be on these hoes next, honey, okay? 100%, baby. Content creating through the damn roof, baby. But, you know, at this point, I'm just trying to survive. Baby, summer got me in straight survival mode. I ain't never been no fan of her. I ain't never been a friend to Miss Summer. I don't never recall, even in the early CTV years, ever asking for the summer, aside from it being a break from having to be a straight A and honor roll student. Shout out to all the honor roll students in life, my God. So, baby, you know, I'm definitely not the one who can get well adapted to the summer. If I could have had it my way, baby, winter would have been the annual season all year round in this motherfucker. Okay? But I ain't the one making all the decisions. So I hope you guys are doing well. Let me speak to you guys. What's going on, Michelle? What's going on, Carolyn? Hey, Platinum 2K. Yes, let's get these likes all the way up. Y'all know YouTube is off the chain right now, girl. YouTube got the girls' live streams glitching, freezing, audio issues, notifications going out, notifications not going out. It's so much going on between YouTube and StreamYard that you might as well just throw both of them hoes away at this damn point, baby. All right. So get the likes up. Y'all know that YouTube be playing in our face all the time when it comes to missed notifications. So please run it up, run it up, run it up. And if I have any moderators in the chat, please encourage the folk to run the likes all the way up. What's going on, my sister? Girl Styles by Stevie, baby. Y'all make sure to subscribe to my girl Styles by Stevie on YouTube, girl. You are my morning dew, okay? I be getting my life off of your political commentary in the mornings, honey, when you be burning your calories and strutting your shit and popping it, baby, and getting all the political tea, honey. So I be listening to you while I be burning my calories and cycling in the morning, honey, and I enjoy it. So if you guys love some good political commentary and you love some good morning radio, child, please subscribe to Styles by Stevie on YouTube. Click on her name. It'll take you to her YouTube channel and subscribe, baby. She is always in her Condoleezza Rice bag. She's always in her Jasmine Crockett bag over there on this YouTube, child. So bless you, Styles by Stevie. And shout out and congratulations on your new home. Gorgeous, gorgeous, beautiful, honey. So shout out to you and the fam and all the blessings thereof and a new beginning. And once again, boo, if you need anything, let me know. I'm only one DM away, okay? What's going on, Tam Tam? Hey, Ian Gardner, what's going on? Kohesta, oh my God. Done caught an old nasty piece alive on Period. What's going on, St. Marquise? What's going on, Tracy? Hey, Simply Telly. What's going on, Katy Perry? Hey, Aquarius Moon, all the baby mothers, all the baby fathers in the building. What's going on, Josh? What's going on, Kyler Bone? Hey, boo. What's going on, Tia? Hey, Todd. Hey, y'all. There's a lot going on, child. So let's get into it. Y'all know that Megan Thee Stallion been taking Milagro scams through there, girl, taking away she don't want to go. Milagro has been trying to convince the courts, girl, that if they allow Megan Thee Stallion to become a debtor like Cardi B is to Trasha Coochie K, and they allow her to begin the garnishment process, that her and her children are going to end up in a luxury cardboard box in the back of Golden Corral, baby. Okay? So she's been begging the courts to halt this motion for garnishment so that Megan can start collecting on her GWAP, her $75,000 off the top. And then after all post litigation is complete, the last and final thing that they're going to do in the case is deal with the cost of production and Meg's attorney and court fees, which I already know, child, going to be in the high 6 digits, if not the millions. But I'm expecting probably nothing lower than 100,000. I'm a range somewhere in between, because they've been litigating now, baby. It'll be going on 2 years soon, and by the time this shit comes to full completion, and then they run that last tab up, it's got to be between 500K and 1 million. It's going to be a mess, and that's going to be on top of the 75K, y'all. So Miss Can't Stop, Won't Stop. So the courts ended up denying her request for a stay because Meg used all of Milagro's own brokenness, used all of Milagro's own argument for why she should have a stay as an argument for why she should be denied of a stay. Milagro is so goofy. She's so lawyerless. Okay, she's been chat GPTing up her argument so bad that AI did not tell her that she was actually making Megan's argument rather than her own. So the goddamn courts, girl, said denied and favored Miss Megan. So she cannot get a stay. So then Milagro tried to smarten it up. So she decided to try to appeal the case altogether, because appealing the case also temporarily halts any type of garnishment, etc. Like all of the issues kind of slow down and come to a halt until a verdict is reached about the appeal, which we're still waiting on. But, and now Milagro is arguing in the context of her appeal that there's a partiality issue. Partiality. She's claiming that the presiding judge over the case has a spouse who is close to Rock Nation affiliates. like Desiree Perez, who you guys know is being sued by her daughter, in the words of Evelyn Lozada. And because the presiding judge has a spouse who's close to Rock Nation and Rock Nation affiliates, Milagro is reaching for stars, moons, solar systems, galaxies, Milky Ways, aliens, grays, reptilians, and Sasquatches, trying to make an argument that, oh my God, this means that there's biasness because obviously Megan is a Rock Nation affiliate. She has a management and distribution deal with Rock Nation, and then the judge's spouse is close to the CEO of Rock Nation. This is partiality. I need a retrial, or this case should be completely dismissed on partiality grounds. Now, Megan had already told that goofy hoe that bitch her appeal was going to be a wash and a rinse, and her request and motion for a stay was going to be a wash and a rinse. So Megan has now responded to Graham's argument for an appeal in order to get a dismissal or at least a retrial on the basis of partiality. So, girl, we're going to get into what Miss Megan and her attorneys had to say, girl, because they chewed her up real bad once again. And the irony is, I told y'all what Megan was going to say. Because I told y'all the last time that we reported on this that, first of all, her argument lacked showing and demonstrating where the partiality actually was. Just citing that the judge is affiliated with or maybe affiliated with in some loose-ass, long-arm-ass way to the oppositional party is not an argument for partiality in and of itself. You also need to not only make the strongest case you can for the bias ties, but also you guys to point out where was the biasness. Where exactly through the litigation process did you feel like you were legally discriminated against? Where did you feel like the judge was being impartial? Where did you feel the judge was being biased? She never listed one example, girl, when she looked through the map of the apocalypse that happened unto her, girl, when she looked at the crime scene, when she looked at the blood work, when she looked at the autopsy report, she did not and could not list, not at any point from top to bottom to the middle of where exactly did the courts show any partiality and biasness toward her. The whole thing was just a strong imagined argument for affiliation, and it was a bad one. Okay. Also, Meg's motion or her argument in response to Milagro's motion or her appeal, she talks about the stay situation as well, even though that's already been in her favor, girl. And, you know, ultimately, like I said before, scams just gonna have to look at Megan as Thanos, baby. Okay, she's inevitable. You're cooked, girl. Just like Balagna in the summer heat, girl. Just throw eggs on the concrete, honey. You're scrambled. You're done. That broccoli been done, honey. What's gooey? You're a wrap. You know, Meg, you begged Megan Thee Stallion for her attention, and now Megan is trying to give you a piece. She's trying to give you a piece, daughter. She's trying to give you the piece that you begged for, granddaughter. I don't understand. Every time that lady said anything on social media, baby, you had to clap back, you had to get back, you had a response, baby, you was in it to win it. I don't know whether you thought that it was your convicted pimp Tory Lanez, who was going to have your back. I don't know if you thought that DJ Academics and Joe Budden was going to run the tab in case anything had happened to you, girl, and then you F8, F-O'd real bad. Real bad. Okay? You needed that. And now Megan gotta run you that. She's trying to give you your peace. Okay? And can you guys hear me before I go any further? Because I got ACs blowing. I got fans blowing, baby. Anything that generates velocity and force is on in my chateau. Yes, it is. But can you guys hear me loud, live, and in color before we get any further into this commentary group? Because I'm going to read you all the paperwork, child, because it's a mess. And while I'm waiting on y'all, let me hold on. I'll be right back. I'll be right back, my child. My baby, my baby, my baby, my baby, my baby. He down, loving me, driving me crazy. Okay, everybody can hear me good. Loud, loud, and in color. Great, child, because I got y'all, baby. Let me tell you, baby, I hibernate right up under the machinery, baby. The machinery do not be afar off, baby. I be damn this legs wide open, sitting on top of the AC, baby. Okay, legs cocked to the heavens while the ceiling vents, girl, are shooting out the glory of God into my soul. Yes, God. Okay, y'all can hear me. So let me pull up a visual, then I'm going to read y'all the paperwork, child. And I may drop the link depending on how long this take. It ain't that many pages. I think we got 14 pages. And then we up out of her. I'll drop the link in case you guys want to pop off and y'all got anything to add, child. I also gave a crazy update on Love Island, girl. They got all type of drama going on, but Love Island 6 cast got it going on right now. Janae and Kenny are going through it, child. All type of allegations of abuse and violence and cops being called and every goddamn thing else done came out. So if y'all missed last night's commentary, get up into that commentary. If you don't know what the hell going on, you don't need to. That's my job, okay? So I break it all down for you. By the time I get finished with you, you're going to feel like you've been following the case, girl, from beginning to end. So even when you see content over here that you think you don't know nothing about, click it any damn way because, baby, I'm going to put you all up in somebody else's goddamn business, okay? You're going to be well informed. So check out last night's commentary because it was improv. It came across my desk. And I had to go live and give my unpopular opinion about what the hell is going on over there on Miss Love Island, child. Hold on, I'll stream y'all acting dumb. See, I'm sharing my screen, but ain't nothing being shared. Hold on. Girl, I'll tell you, girl, I don't know what it is. I know we in the shadow period of retrograde. I'm going to assume that's what all this is about. Okay, so let's get into the paperwork, child. This is Megan Pete versus the Koopa. The plaintiff and appellee. Megan Pete responds to opposition to defendant appellate Milagro Elizabeth Scam's motion to stay briefing schedule and hold appeal in abeyance for the reasons set forth herein. The motion should be denied. Appellate asked this court to suspend her own appeal indefinitely with no date certain so that the district court may first rule on a Rule 60b-6 motion that appellate filed 7 months after an adverse jury verdict, 40 days after the amended final judgment, and 9 days after the district court denied her motion to stay enforcement of that judgment. The premise of the request is that the federal rules indicative ruling procedure functions as intended only if the appeal does not proceed. Hold on, y'all. Hold on. Lost my place, child. Appellate has it backwards, as always, baby. Megan, you know this hoe is dizzy. She argues that the appeal must be paused so that the district court can rule on her motion first. But the rules she relies on, Federal Rule of Civil Procedure 62.1 and Federal Rule of Appellate Procedure 12.1, were created to let the district court consider a post-judgment motion without pausing the appeal. The reason that those rules exist is that filing an appeal strips the district court of power to grant such a motion on its own. So the rules let the district court review the motion, and if it is inclined to grant relief, say so, at which point the appeals court can decide whether to send the case back. That process is designed to run alongside the appeal, not to halt the appeal. Filing a Rule 60b-6 motion in the district court, therefore, does nothing to this appeal. It neither stops the briefing schedule nor extends any deadlines, nor do the traditional stay factors help appellate. She bears the burden of making out a clear case of hardship or inequity, and she identifies none. The only hardship asserted is that she may have to brief her own appeal. The efficiency rationale fails on its own terms because the underlying Rule 60b-6 motion seeks to vacate a jury verdict based on an alleged appearance of partiality inferred from social media posts concerning non-parties. As explained in the plaintiff's district court opposition, the motion is meritless, untimely, and waived. A stay here would simply delay the resolution of an appeal from a judgment that plaintiff obtained from a jury more than 7 months ago. So Megan is arguing so far that, bitch, it's a reach, okay? And you're dumb. And you still have a lackluster, mediocre, speaking of partial, girl, partially argued motion for a stay that in no way provides any substance behind your argument of why the court should show what would really be an exception to your foolishness. You are trying to convince the courts that you're broke and you don't have no liquid, you don't have no material assets, that you don't have nothing, that you cannot fulfill a supersedious bond, but you also haven't even proved that you are in fact just that broke. Now, Scams did say that she would be willing to prove just how stinking, raggedy, embarrassing, and iconically broke she is, but she would like to do so under seal so that the public can't roast and gag her motherfucking ass, okay? Well, the courts, as I said earlier, already ruled on Milagro's motion for a stay and denied. So she will have to produce that supersedious bond under the circumstances that she claims she can't, and there won't be any seal. So at some point in time, what she will be forced to provide to the courts as it relates to her finances, those finances, it's just my finances. It'll be open transparency for the public, my God. Milagro really just might as well join the goddamn Illuminati at this damn point, bitch, because this is a clear humiliation ritual. And I had told that banana face ass heifer long time ago, before it even had got this deep, that Megan want blood out of you, ho. She want blood out of you, darling. Daughter, granddaughter. Megan wants blood out of you, and she's going to get just that. She also has set up that nice little deposition with them ex-camp mob members about that alleged child corn that Milagro allegedly had sold, girl, that's now being investigated by the Child XCS Trafficking Unit of Texas. And those ex-camp mob members who sat for a deposition in the Megan Thee Stallion lawsuit now have their own lawsuit against Milagro that she's also simultaneously litigating while also battling the Teflon Don in court, on top of the feds building their own case against her. My God, today. It's the blood of all blood, girl. They're going to make skins out of you in the Mortal Kombat 3 installment, baby. Yes. They're going to be adding you, your skins, and Megan Thee Stallion, girl, as characters in the next Mortal Kombat 3 installment. Yes, they are. My God. And Megan is also arguing that you're a little bit too late, bitch. You didn't have nothing to say about no appeal. You ain't find no issue with the verdict because you thought that you had ran me that when that little defamation count got dropped in your favor, honey, and you was out there with them free ass attorneys who done ran for the hills because they don't work for free. And you was just feeling real good about yourself, girl. Got online with Barnyard Wiggins and sat down with Unwinding with Cardi B's money. And, you know, but baby, you ain't had nothing to say about the jury. You ain't had nothing to say about the judge. You ain't had nothing to say about how the case went, baby. You was happy to have put it all behind you and to go on with your life. And now all of a sudden that you done re-gaslit Megan with your narcissistic self-aggrandizing tactics, and that little defamation count that wasn't your favor got reverse uno'd in Megan's favor because you told y'all hoes that when she stepped out, it gets scary for you hoes. And now you understand the depth and the severity of the consequences and repercussions of your actions. You now are pleading for mercy and sympathy, and there was none of this humility ever demonstrated the entire time before it had ever got this dark for you, my God, today. And nobody want to hear it. The judge don't want to hear it. The judge is denying every goddamn thing. And Meg is asking for the most. And you know, because Meg and Cardi are cool, that you know Cardi is giving Meg the play-by-play girl on how to take you through the nooks and how to take you through the crevices of the federal court system, baby, to make sure that by the time this is all said and done, that there'll be a motherfucking tombstone on top of your goddamn head. Oh, my God. My God. My God, my God. Y'all run the likes all the way up. Y'all know the cane works, baby. Okay, I works. Background. A jury found appellant liable to appellee for defamation per se, promotion of an altered actual depiction in violation of Florida law, and intentional infliction of emotional distress on September 1st of 2025. The district court entered the final judgment on December 2nd of 2025, and after resolving post-trial briefing that the parties had expressly reserved, entered an amended final judgment on counts 1, 2, and all 3 on May 29th of this year, awarding Megan $75K off the rip. Appellant first noticed this appeal on January 2nd of 2026 from the original final judgment and filed an amended notice of appeal on June 30th of this year. From the amended final judgment, the rulings merged in it. Neither notice raised any question about the district judge's impartiality. The theory that appellant now presses arose on her telling only after she lost. My God. On June 29th of this year, the district court denied appellant's motion to stay enforcement of the amended final judgment or reduce the supersedeas bond. 9 days later, on January 8th of this year, appellant filed a motion under Rule 60b-6 asking the district court to vacate both judgments based on an asserted appearance of partiality under statute 28 U.S.C., together with a request for an indicative ruling under Rule 62A3. The theory, the presiding judge's spouse is a partner of Holland and Knight LLP. Other lawyers at the firm represent Desiree Perez, the CEO of Appellee's management company and a non-party in an unrelated case before a different judge. Therefore, the judgment should be vacated. Appellee's opposition to that motion is due July 21st of 2026 and will demonstrate that the motion fails on the merits, is untimely, was waived, and identifies no extraordinary circumstances. In other words, baby, there's nothing to see here, Judge. Not a goddamn thing. Okay? Appellant does not seek the district judge's recusal from anything. She seeks only vacatur of the judgments she lost. 2 days after filing the Rule 60b-6 motion, appellant filed the present motion asking this court to stay the briefing schedule. Appellant's opening brief is due August 10th of 2026 and hold the appeal in abeyance until the district court rules with no outer limit. Here's the argument. Nothing about the pendency of Rule 60B motion suspends an appeal. The only interaction that the rules recognize between the Rule 60B motion and appellate timing is Federal Rule of Appellate Procedure 4A under which a Rule 60 motion tolls the time to file a notice of appeal, and then only if the motion is filed no later than 28 days after the judgment is entered. Appellant's ruling 60B6 motion was filed on July 2026, 40 days, not 28, but 40 whole goddamn days, baby. It took her just as long to file for her appeal as it did for Jesus to conclude his conflict with Saturn or Satan in the wilderness. My God. 40 days after the May 29th of 2026 amended final judgment and more than 7 months after the original final judgment, it tolls nothing and no rule extends or suspends the briefing schedule of an appeal already pending. The indicative ruling framework confirms the point. Because a notice of appeal confers jurisdiction on the Court of Appeals and divests the district court of control over the aspects of the case involved in the appeal. See case law here. Rule 62(1) authorizes the district court to entertain a post-judgment motion that it lacks authority to grant and expressly empowers it to defer considering the motion, deny it, or state that it would grant it or that it raises a substantial issue. Federal Rule Civil Procedure 62(1)A, Rule 12(1) in turn requires nothing of this court unless and until the district court states that it would grant the motion or that it raises a substantial issue. Only then does the question of remand even raise. Federal Rule Appeal Procedure 12(1)B, the rules therefore contemplate that the appeal in the district court proceedings will continue in parallel. The appeal proceeds while the district court considers the motion. Appellant's assertion that the procedure functions as intended only if the appeal does not proceed to full briefing has it exactly backwards. If the rules intended appellate proceedings to halt whenever a Rule 62(1) motion is filed below, every judgment debtor could suspend her own appeal at will by filing a post-judgment motion, however meritless. The rules create no such mechanism, and this court should not create one by discretionary stay on this record. So once again, she's making the argument, baby, that if anything, there's nothing present, there's no precedence within the law that absolutely obliterates this process. If anything, there are systems that can be resurrected and argued to exist alongside it, but not ultimately to destroy it. And that's ultimately what Milagro is actually asking for and begging for, and is failing to fucking argue, which is why the courts and myself are calling it an exception. The bitch is asking for some exceptional precedents within the law. And Megan is arguing the actual law to demonstrate why that will be illegal, procedurally erroneous, and that the courts bet not fall for this bitch's begging and her woe is me narrative. The motions rest entirely on case law here, cited for the general proposition that courts have inherent power to stay proceedings. Notably, in Landis, the Supreme Court vacated the stay under review. The court held that a party seeking a stay must make out a clear case of hardship or inequity in being required to go forward if there is even a fair possibility that the stay for which he prays will work damage to someone else. and that a stay immoderate in scope or duration is an abuse of discretion in statutes here and here. Even the stay at issue in Landis' case was narrower than what Milagro seeks, and the Supreme Court still vacated it. So baby, she arguing, girl, there are cases that were better argued, even better situated for what Milagro is arguing, that was still vacated. So how much more should what the hell this bitch is arguing should be vacated? My God. There the stay was to last only until a designated test case resolved the identical constitutional question, so the court knew exactly what it was waiting for and why. Milagro's requested stay has none of those factors. It waits on a motion that raises no issue now before this court. It has no fixed endpoint, and it is tethered to a district court filing whose defects are apparent on its face. If the Landis stay was too much, then this one is far more so, your judge. The court applies the same principle. A stay that is indefinite in scope is immoderate and impermissible, such as in case law here and here. And the burden of establishing the need for a stay rests at all times on the movant, such as in case law here. Appellant identifies no hardship other than the obligation to brief the appeal she herself filed, an ordinary incident of appellate litigation, not the clear case of hardship or inequity that Landis demands. The prejudice to appellee, by contrast, is concrete. Appellee, Megan that is, holds a jury verdict that is now more than 7 months old, and she has a strong interest in seeing this appeal resolved promptly and with finality. Okay, Teflon, now you better pop your shit. An indefinite stay would defer that resolution while appellant continues a series of post-judgment maneuvers. First, a motion to stay enforcement, which was denied. Then a motion to vacate filed 9 days after that denial. And now a request that this court pause the appeal in deference to that motion, where there is at least a fair possibility that delay will harm the opposing party, and there is far more than a possibility. Landis places the burden on the movant to justify the stay. Appellant has not carried it, my God, today. Appellant sufficiency argument assumes that underlying motion has a realistic prospect of producing an indicative ruling in her failed ass favor. It does not, for reasons that appellee has set out in full in the district court and summarizes right here. First, the statute 455, a theory fails on the merits. Neither the presiding judge nor her spouse nor his firm has any interest in the outcome of this case. No Holland and Knight lawyer has ever appeared in it. The firm's client, Mrs. Perez, is not a party to it, and Ms. Perez's separate litigation is pending before a different judge. Every authority that appellant invokes involved a far closer connection than anything here, such as in case law here and here, where the judge himself served as a trustee of a university that stood to gain financially from the outcome of the very case before him. Such as in case law here and here, the judge's brother was a partner in the firm, serving as counsel of record in the case the judge was deciding. Nothing of that kind is actually present here. Indeed, in case law here, cited in appellant's own motion, the court declined to vacate a judgment, even though the judge's son was an associate at the firm representing a party in that very case, holding that any statute concern was harmless under the same case law factors appellant invokes. Second, the motion is untimely and appellant's argument is waived. Disqualification claims must be raised at the earliest possible moment after obtaining knowledge of facts demonstrating the basis for such a claim, such as in case law here. By the motion's own account, appellant's entire theory was published on X on September 27th of last year, 7 weeks before trial, while appellant was represented by counsel in a post expressly discussing the presiding judge and Ms. Perez, and even on appellant's own telling that she learned of the theory on May 29th of this year. She then spent the following month asking the district judge for discretionary relief on her state of enforcement motion without a word about disqualification, raising the issue only after the motion was denied. The sequence reflects tactics, not diligence, and Rule 60b-6 affords no relief from free, calculated, deliberate choices, such as in case law here. Thirdly, the supplemental facts in Exhibit D, a notice subsequently docketed in the district court without leave, make appellant's position worse, not better. Appellant first asserts that Holland and Knight, through its Houston office, previously represented appellee in Harris County litigation, but her own exhibits identify those actions as disposed, and the latest identified action was dismissed with prejudice before this lawsuit was even filed. That concluded representation is even more attenuated than the relationships found insufficient to require disqualification in case law here. Appellant distinguished those decisions below on the ground that the engagements at issue had ended. She cannot now rely on a representation that ended before this lawsuit began to establish an appearance of partiality, nor is this fact new. Appellant's exhibits show that Holland and Knight's representation of appellee was reported in the entertainment press by 2022 and appeared to public Harris County dockets well before trial. Appellant's other supplemental assertions were equally unavailing. So Megan is saying this information that this weak asshole trying to now put up to the appeals court under the guise that, you know, there is an issue of impartiality because of the judge's spouse's connection to her first cousin, second baby daddy's Rock Nation affiliate Desiree Perez, actually was long-standing information that's been publicly available at least since 2022. So if this hoe was going to argue this case, especially with her being a quote-unquote media defendant, even though we know had the bitch really done her due diligence like she should have did in the Megan case, the bitch wouldn't be here at all. But if she was truly and had truly been on her journalistic integrity, had she done her journalistic due diligence, had she actually lived up and fulfilled the standards of being a media defendant, the dumbass, goofy motherfucker would have known all this information since 2022 and should have then argued these issues before the case even set off and hit the ground running, and she didn't. You know why? Because the bitch know it's meritless, and the only reason she trying to throw this shit at the court now is because it's a scheme that her and Todd came up with in order to deflect from me putting this bitch and her motherfucking football head ass kids in a goddamn cardboard box out the back of the Piccadilly. My God. Girl, she's cut, girl. Megan is eating her alive in these motions, my God. Girl, why this lady won't get her an attorney, girl? Because Claude AI and Chat GPT, girl, is not doing scams any service. My Jesus. This is a mess. Appellant's other supplemental assertions are equally unavailing. Holland and Knight's 2026 representation of Rock Nation in unrelated Texas litigation involved no party to this case and no issue presented in this appeal. The January 2024 administrative order is even further removed. 9 months before this lawsuit was filed, the chief judge appointed 12 members, 2 judges, government lawyers, court staff, and several private practitioners, one of them a Holland and Knight partner, to a committee studying the district jury pool. No reasonable observer could infer partiality from a former representation that ended before this lawsuit, an unrelated representation of a non-party 2 years later, or a routine administrative appointment made before this case even existed, because the underlying motion will not survive. Staying this appeal in deference to it does not conserve resources. On the contrary, it will add months of delay to an appeal that can and should proceed on schedule. If contrary to all indications, the district court were to state that the motion raises a substantial issue or that it would grant relief, Rule 12(1)(a) provides the mechanism. Appellant notifies the circuit clerk, and this court decides then whether to remand. That sequencing react to an indicative ruling if one issues rather than presume one is the procedure that the rules prescribe. The scheduling conflict appellant describes is limited, and she created it herself. On her own account, appellee's opposition to the Rule 60b-6 motion is due July 21st of 2026. Appellant's reply follows about a week later, on or about July 2nd, and her opening brief in this court is not due until August 10th. This leaves the district court time to rule, including simply to deny the motion under Rule 62(1)(a)(2) before appellant opening brief comes due. Any overlap that remains in a product of appellant's own timing. She waited 40 days and 40 nights after the amended final judgment to file her Rule 60b-6 motion, and she filed it only after the district court denied her motion to stay enforcement. She then waited 2 more days before asking this court to stay the appeal. Having chosen when to file each of those motions, appellant cannot use the resulting calendar as a reason to suspend the appeal she filed, nor does her former counsel's withdrawal supply one. Any problems her former counsel's withdrawal cause concern her own compliance with this court's requirements. The missing civil appeal statement, for instance, not the Rule 60b-6 motion, and not whether the appeal should be paused. If the court concludes that appellant is entitled to some accommodation, the answer is short, fixed extension of her opening brief deadline, a new date certain, not an open-ended freeze of the whole entire goddamn appeal. An extension keeps the appeal on a schedule the court and the parties can plan around. What appellant asks for instead is a stay with no end date, lasting until the district court happens to rule on a motion this court cannot control the timing of. Baby, when I tell you, Megan is working, girl. Baby, she is working the system down, baby. Megan, at this point, ain't playing with Milagro, and her ass ain't playing with the goddamn court either, baby. Mamas is swinging at this goddamn point, girl. She said, enough. 1, 2, 3, release it, bitch. Okay, on period. That is the kind of open-ended, immoderate stay that Landis and Ortega case law here hold a court may not enter. Conclusion. Appellant's Rule 60b-6 motion stay nothing, toes nothing, and for the reasons set out above and in appellee's district court opposition will change nothing. Plaintiff appellee respectfully requests that the court deny the motion to stay briefing schedule and hold appeal in a Beyonce in its entirety and maintain the current briefing schedule. The response complies with the type value limitation, So, boom, wham, bam. Thank you, motherfucking ma'am, baby. If the best predictor of the future is the past, we can expect the court's response to be denied as it relates to Milagro's request, girl, to halt this hearing and to propose this appeal under what is in fact bullshit. She should have took my advice. She should have filed for bankruptcy because it was clear from the jump. You know, it's one thing to have a case that a person can actually win, okay? It's another thing when you have a case that is a clear, open, and shut situation, and this would be one of those goddamn cases. There was no way for her to win. She absolutely and arguably, objectively taunted a deep fake SCX of this lady. There are recordings of her promoting this link. They had Zelle payments between Tory Lane's father and the paid surrogate. They had literal her coming in and out of the courthouse as a media defendant during the shooting trial, and yet still went online to post complete and utter dis and misinformation about the goddamn case. Just told straight up lies. Like, you know, the LAPD had lost the gun, which made the LAPD have to respond in the case and say, actually, no, we still have the gun. Typically, in criminal cases, we don't actually bring the physical weapon. We bring pictures. You don't actually see the damn GUN. You don't see the bat that was used. This is not the damn OJ trial, okay? Miss Milagro, because she ain't never been nowhere except to the 7-Eleven and to a damn trap house, didn't know that they don't typically show the actual weapons physically in court, that they present pictures as evidence and exhibit A through damn Z. So, girl, it was a mess from the jump. This what you said, the lady was an alcoholic. You said the lady had a handler. I mean, you went on and 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 on. My God. Once she clocked that Joe Budden, academics, and Tory Lanez was not going to be fucking with her, girl, and they wasn't going to be putting nothing on her books, that's when that bitch should have went to get into mediating with Miss Megan, girl, and apologizing and signing damn gag orders and, you know, giving up her First Amendment on this damn lady. That's when she should have went to getting the swinging for her life. Once she fully realized that, first and foremost, she didn't have no possibility of winning because the evidence against her was black and white, girl. It was littered from one end of the castle to the other end of the castle wall. And that she didn't have no funding and no sponsors. And she realized, girl, that her and her tax bracket was completely out of its own league. That's when she should have sobered up off of the clout chasing and sobered up, girl, off of the endorphins and off of the damn serotonin hits that she was getting because she thought, you know, that going through this with Megan was about to catapult her. And it did. Catapulted her ass right into poverty. Where Megan Thee Stallion intended your ass to be from the very beginning, baby. Mission was goddamn accomplished. And Milagro so stupid that she allowed Megan to set her ass up because something else that the banana face hoe was banking on is she thought because Megan had so many ops between party, between academics, between Joe Budden, that for whatever reason that was going to prohibit Megan from taking legal action against her. That's why the whole time they was litigating, she kept coming out here to the court of public opinion talking about, but it's other people. It's other people that was talking about her and slandering her and saying some of the same things that I was saying too. Bitch, you're goofy. You're goofy if you thought that you was going to have some type of qualified immunity because you was gang banging this woman and because you was one of many men who wished death upon me, that somehow it was going to keep Megan's foot from off of your fucking neck. And I always tell y'all, it don't matter whether you do shit solo or you do shit as a member of Destiny's goddamn Child. If you take your ass out there with a group of other bad behaving, law breaking ass godless heathens, and you start throwing rocks at somebody's car, and y'all do that as a group, and then that person comes out of their house and see y'all damaging their damn vehicle with them rocks, that person who now has defaulted to a plaintiff gets to decide. It is of their personal preference if they're going to be running the entire group to the courthouse, or they're going to be running whom of their personal preference to that courthouse. And it may be all of y'all or one of y'all, but you should never think that just because there's a bandwagon and other people on that bandwagon that somehow you got a safe corner to hide in or to argue out of, because the reality and the privilege that Megan Thee Stallion has is that she does not have to hold anybody else accountable if she does not want to. If she never sues DJ Academics, if she never sues Joe Budden, if she never sues Aiden Ross, if she never sues Tory Lanez, if she never sues anybody who's ever put their raggedy, rabied ass mouth on her, she doesn't have to. And there's not a goddamn thing that Banana Face can do about it. So sitting there arguing that, well, you know, it was a lot of us. Girl, you in a versus match alone with you and Megan. And all the other remaining members of Destiny's Child who ganged up on that damn lady done ran off to have solo careers, girl, and left your ass high and dry looking dumb, broke, and goofy. And how embarrassing and intellectually dishonest is it for you to convince yourself that she didn't have a right to sue you because, in your personal opinion, as the abuser and as the perpetrator and as the victimizer, there were other people who did worse, or because you wasn't alone in this Rico. My God. Now the freak code is being taken through a non-Rico. Jesus. Let me read some thoughts, girl. Then we're going to get up out of her. The court's going to side with Megan. It's going to be another denied. And then I really don't know what the whole going to do, baby. Okay, I told her, either file for bankruptcy, bitch, or fake your death. If y'all see a headline in the next few weeks, girl, that Milagro's family van was found burnt beyond recognition, bitch, and they were only able to identify the remains by a single tooth or toenail clippings, bitch, the scheme and Todd and Milagro have been successful, baby, and she would have taken my advice to fake your damn death, bitch, because you're going to need a whole head transplant to get up out of her. Everything Beauty by Courtney says, that's like getting pulled over for driving drunk and say, I shouldn't be there. Exactly. I shouldn't be the only one to get a DUI. Other people were drinking. That's the way she thought it worked. That's the way she thought all of this worked, girl, because there was other people coming from the club zooted up on that good Hennessy, child. That should disqualify her from being pulled over and arrested and having her car towed and catching that DUI charge. My God. Babe, talks with XO. We've been live for an hour now. I'm about to get off. I just concluded reading the paperwork, child, of Megan responding to Milagro ass in court. You got to catch the replay, boo. All this for a man when you have 2 kids and a wife. I mean, Joy says, why can't all these Tory Lanez supporters raise her enough money to get a proper attorney? Well, because the Goofy was too busy the first time she tried to play on the public's head top and used a lot of the money to go to Chris Brown concerts and to buy kinky straight middle part 30-inch human lace bust downs. And that's why her attorneys, girl, was submitting memorandums to withdraw from the case, claiming that they wasn't getting paid and they can't work for free, baby. This ain't the Oliver Gospel Mission. They don't do no charity work. And then she had people calling for a boycott and a recall on their coin. Because why your attorneys out here saying they ain't get their moolah? My God. Todd says to not only try to petition the courts to give an infinite say of judgment because my ish isn't together, but the gag of it all is to use the wrong court language to do it. My God. Baby, she better get to selling some. See, baby, she better she better go find what's his name? Brian Ponder, Tyrone Blackburn, baby. See if they would take equity in the form of coochie, baby. You baby, in the words of Harani from Players Club, bitch, you better use what you got. So I ain't talking about ChatGPT to guess what you want, girl. She better start looking through the yellow pages. Get her an old school phone book, child, because she's going down in a blaze of goddamn glory. And to double the trouble, this ain't even the only litigation that you in, girl. You got your ex-camp mob members taking your ass through there in a whole separate goddamn lawsuit, and got the damn child SEX trafficking unit of the damn FBI building the case against you. Girl, you know what? Fake your death, honey. Fake your death. I got to get out of here, y'all. If you enjoyed yourself, run the likes all the way up, subscribe, share, all that good jazz. Tell a friend of a friend of a friend, girl. Share on Twitter, share on Tumblr, share on Facebook. Get the folk up in here. Turn your fave into all your friends and family's fave as well. If you enjoyed yourself, please give me a thumbs up. If you didn't on the way in, at least on the way out, the thumbing up helps us so much, you guys. We need all that because YouTube is always playing on our head top. If you also want to bless the king, you can always do so at Cash App, $Consciouztv on Cash App and or PayPal.me/Consciouztv. I will keep you guys updated as always. This was great. This was fun. Have a wonderful Tuesday. Keep your notification on. Also check in on the platform manually because YouTube do not always send out notifications. I may be circling the block tonight. Okay, I may give y'all one more. So keep your notification on. I love you guys. Peace.